Happy Friday. Happy Friday. Happy Friday. Hello, all. Weekly privacy chat here. Just me this time. No special guests. We have a day off today and give the staff a little time to catch up on their writing, on their mental health, on their work and their family. But I did want to connect to share just a little bit of what's going on with many of you who follow some of the same issues as I do. So obviously lots of big news coming out of Washington, and I think you get your political commentary in many places other than LinkedIn. I'm not sure I can add a lot that you haven't already read. I will say that for those of us who live here, I often feel like I don't live here because I'm a native New Yorker and spent the first chunk of my career in both government and private sector in New York. And was born and grew up there, and now spend a huge amount of my time globally in Europe and the APAC region, Israel, beyond. But my family, my house, our main office is here, and lots of people affected by the government reductions. A lot of young people. This week, a lot of people who are on probation, which is the status many have their first year or two. So a lot of people who came out of college and turned down significant opportunities because they wanted to do public service were just summarily dismissed. Look, there's a lot of room to reform government. There's a lot of places to make reductions. And I do believe that with a will and a way and expertise, you can have some real cost savings. But I am indeed frustrated at sort of random burn it down, slashing. Maybe that can happen in industry when the problem is that your product maybe doesn't work as well. But it's certainly a challenge for government when the services affect lives. So I do hope that as reform proceeds, and there is a mandate for that, that it can be done with nuance, with respect for privacy and security. If government systems are being accessed, no excuses when we are all under threat. Anyway, maybe that's already getting a bit political, but I don't mean to engage the politics of it. We all have our views, but I do think that for those of us who work in privacy and security, it's fair to look at the impact on privacy and security and make the case for whether the goals can be achieved without wreaking havoc. Hoping for the best. So Europe was obviously the big news this week as countries convened around the Paris AI Summit. Kamala Harris had a leadership role in the AI portfolio, so it was interesting to see that J.D. Vance was the U.S. representative. Obviously, his message was very different. It was interesting, his message wasn't about GDPR, which is probably the one real place where there's a lot of uncertainty about how generative AI and advanced AI is suitable in Europe, whether you can scrape data and use it for purposes that were not initially intended under the obligation to have either consent or legitimate interest or another legal basis. Huge open question in Europe, whether models have to delete data when the state of model unlearning is still uncertain. What do subject access rights look like? Now, DPAs have been giving us guidance. Camille had some useful guidance just recently, other DPAs as well. But the EDPB guidance here really wasn't determinative. The Irish DPA will need to make a decision in the action it has against OpenAI. And lots of the debate seems to be, although Vance didn't raise the EUA Act, he raised the DSA. And obviously we know the administration's concerns that speech shouldn't be censored. The area where I think there is significant stress, where certainty needs to be provided is GDPR. But many of the U.S. free market folks are very focused on the EU AI Act, which again has its challenges. But when it passed, there were many who were relieved that it had some nuance in it, for instance, between high risk and low risk. The complexity, of course, we've published a diagram showing the incredible number of regulators, and obviously there's a host of very specific issues. But whatever happens to any interpretation or reform under the EU AI Act, and again, the conflicts and the tensions between all the multiple data acts and GDPR and the EU AI Act, in my view, are the biggest problems, more than any of the specific clauses, and the reality that the amount of coordination and guidance and complexity that's going to be needed just to provide the path forward is an overhang. Now, look, I'm not one who believes that the reason Europe doesn't lead on AI is because of regulation. Again, folks much more sophisticated than than I, but I'll share my take. The one thing that, for better or worse, has really driven success in the U.S. ecosystem, in Israel, in Singapore, in a number of jurisdictions, is money. Investors shove huge amounts of money, making sometimes wild bets on entire sectors, ready to lose money, ready to invest in multiple competing companies in the hope of having a giant payoff because of one, mega superstar that will grow so fast. Companies, therefore, even at the startup level, are urged to grow. No insistence that they have any revenue, no insistence that they have any immediate business plan, but that they win, they grow, they achieve market share, with the assumption that if you do that, all those things come along later. It's not the intellectual academic work that happens around the world, happens in top institutions in Europe and elsewhere. It happens in terms of companies, having executive talent and operational. Again, there are folks working in global organizations around the world. The unique win at all cost, and if not, fire and move on. And yes, the fact that you can more easily terminate employees and just start up again, and that the debts are not considered a lifelong shame, and the fact that there is less of a safety net, and there's just a huge community of people who've done this multiple times, who know how to put together a company, chop it up, sell it, buy it, finance it, and find the CTO, find a product officer, find the minimum value, and then go, 24/7 to grow that fast and to build the technology and keep rolling things out is a unique environment. Regulation plays its role. I'd argue it's more the uncertainty created by regulation that isn't clear, as opposed to rules saying you can't do X. When there's clearly a you can't do X and other jurisdictions are allowing it and there's value to it, legislators can react. It's not clear. I can't tell you, as somebody working 30 plus years in data protection and working with both GDPR and its predecessors, doing compliance at companies and working with many of the CPOs today, AI regulatory leads, I can't tell you for certain whether generative AI models are operating under the GDPR properly, and I don't know that any council can tell you that with certainty. Again, DPAs have been given some guidance. I think there's good arguments to be made, but there are complaints and counter arguments, and DPAs with much more narrow or concerned views, or who believe that maybe this ought to be allowed, but you got to amend GDPR because it just doesn't allow it under a legitimate interest, for instance, to use data for those multiple purposes. Okay, but that being said, I think we're now eager to learn if the US doesn't think that the European model for AI is the right model, then what is our model? So of note, the Office of Science and Tech Policy is taking input. has a RFI, request for information, a formal way to provide input, and lots of groups will. And I have been reading the guiding principles that different think tanks and free market folks have been putting out, and a lot of it is don't do this, don't do that. Or if you do, focus only on things like child sex abuse material, deep fakes, and so forth. And if you do anything more broadly, do it with an eye towards, supporting innovation. Okay, well, what does that mean, right? How do we give guidance around fairness without invoking, cultural conflict words, when, of course, we don't want to violate, I would assume, traditional civil rights or do things that consumers are going to feel is unfair and perhaps hard for the FTC to reach under its current authority. So stay tuned. Trump 1 issued an executive order on AI and OMB guidance that was quite reasonable, focused on risks, focused on protecting civil rights, focused on making sure the agencies both used AI but had rules in place. And although the Biden EO is, up for suspended, up for major revision, it'll be valuable to see the guidance. Nobody wants the IRS using an algorithm to, determine who to audit in a way that is terribly abusive. And those rules do need to be in place, and we'll see how the administration goes about doing so. Privacy law, again, everyone's always prognosticating, but Representative Guthrie, the new Energy and Commerce Chair, has hired some good staff, some very savvy people from the private sector, and has put together a very big group of legislators and invited input from stakeholders. I think there'd been a lot of feeling that the House in the last session had sort of circled its wagons around the major legislative model and was not eager to hear where the proposals needed to be improved. Any change would each time have another stakeholder group angry. And so they, I think at some point, sort of battened down their hatches and were just trying to move forward, and in the end did not. So it does look like they're opening up a process. Obviously, there's interest, we've all heard already, from Senator Ted Cruz to perhaps looking at the Texas model. Industry has looked at that. Interesting to note that the sponsor of the Texas privacy law, a very serious senior Republican, is also the sponsor of a very serious senior Texas AI bill. Frankly, one that I think needs work. It's a very tough one, informed by his serious expertise, but also serious concerns, and many stakeholder meetings that he had in his work with the Texas Public Policy Foundation and other local stakeholders in Texas. His bill, interestingly, is not one that was brought to the multi-stakeholder AI working group that FPF helps coordinate, where many legislators talk and learn and engage with each other. It recently was presented, just recently, after it was introduced and discussed in a public event. You can take a look at our YouTube page for the video, where other legislators and industry and other stakeholders gave him feedback on it. But this was very much a homegrown effort, and I expect he'll continue to evolve it as he did with his privacy bill, which really started out quite comprehensive, and then with lots of input, ended up in a much more pragmatic place, and now is being discussed as a national model. I hope that will happen as well with this so-called Triaga, so stay tuned. Well, what else should we mention? Korea. Because of language issues, some of the very sophisticated work that happens by the authorities in Japan and Korea, major economies, major companies there, expert regulators, don't always get as much visibility and have as much influence as they should have. Korea, Japan have both done interesting work over the years on pseudonymization and treating that as a serious category to be treated more flexibly when you do serious pseudonymization, not trivial pseudonymization. Europe perhaps is going in this direction via the courts with now a range of decisions, but those who analyze the EDPB guidance, in large part viewed it as almost a counter argument to the judicial decisions, which again are not yet final and may be influenced by the EDPB, but it certainly didn't seem like it was capturing sort of the current state of the cases. I hope to read this weekend Sophie Stella Bardon, I'm messing up her name. I'll post a link to some work she did where she argues that there's some value to the EDPB guidance and that it is in some ways consistent with the court decisions. But that seems like a contrary view from my perspective, but I want to hear more. But Korea provided some guidance aimed at their edtech sector and primarily. Lots of interest, obviously, in understanding how students are doing and the effect of COVID and who's learning and how different schools and different models are succeeding. And if you anonymize data at a high level in a super safe way, you lose lots of detail about poor kids, about kids that may have been impacted in specific ways. And a pseudonymization model provides lots more detail. So they provided guidance, the data protection regulator, on how they were looking at serious privacy protective pseudonymization. Eloise Corton, a leading Canadian lawyer and expert on DID, and Khaled Al-Imam, who's working currently with the Ontario regulator. And I wrote a number of papers during the period where GDPR was being drafted around questions for personal information versus pseudonymous data. And we proposed what we called protected pseudonymous data. So not a cookie that's bouncing around the world with everybody having the ability to link additional data to it or having identities behind it. But hey, I don't have that. I have just a cookie, so it's pseudonymous. No, not that. But key-coded, one-way hashed data sets used for a specific set of time with the key only available to the party that created the data sets, and is that pseudonymous in the hands of others. And again, I think the Breyer decision and others have opened up that path. So thinking hard about whether there's, and again, whether you call it protected pseudonymous data that gets more flexibility in not being subject to all of the restrictions of data protection law. Maybe access is recognized as not feasible. Maybe secondary uses, are permitted. And again, there's room for some of this in GDPR, and we'll see how the courts go. But we'll post at some point soon a translation, or just grab it and use one of the AI tools to translate the guidance from the Singapore, the Korean Data Protection Authority. Anyway, something of note that you may not have missed, but of course our global team took note and is sharing it in our APAC reports and our global reports, which we send to our members. You can become one. Contact me. Maryland, where I actually live, our office here is here in DC, but I live in the suburbs. The DC metro area roughly includes northern Virginia and the close-in suburbs of Maryland. Maryland passed a very strict data minimization law, no exceptions for research, very strict rules around sensitive data. Maryland is in a huge budget deficit. Maryland is very heavily dependent on research. One of our prized institutions, many of my neighbors work for the National Institutes of Health. Huge institution funded by billions and billions in government money that both conducts and funds significant research in the US and around the world with partners. This umbrella of agencies is a critical employer, funds critical work in Maryland. And so when this bill passed, it was somewhat surprising because many other state laws do have much more flexibility for research. And Maryland was the first with this sort of very strict data minimization. And so to the governor, who's desperately looking for revenue, I warn you that this is something that will have impact, and you might want to look at this before it hits you like a ton of bricks. Let me grab this state report, state AI report that our team puts out. And let's note that Virginia, the House has passed Delegate Maldonado's AI bill. Virginia has a very quick session. Bills have to pass both houses by a date in February, which is coming up. So we'll see the prospects past pretty much party line. It is now more flexible, I will say, than the initial text in how it treats AI, and I urge people to take a close look at it. Senator Rodriguez of Colorado is back with some additional focus on AI. The Colorado task force that's working on updating the law published an interesting report showing where there's consensus, changes that everyone agrees need to be made to improve, and then other areas where they still need to debate and discuss. So we're optimistic that that Colorado bill could end up being a valuable model. Many other states have modeled off of it. There is no model state bill created by anybody, nor created by the Colorado law or by the FPF multi-stakeholder working group. It's true that the first state to pass laws ends up being one that other legislators look at, and both Connecticut and Colorado, which were being worked on at the same time by two legislators who did work together, Maroney in Connecticut and Rodriguez in Colorado, and certainly, saw what each other was doing. Certainly, there are aspects of those bills that are emulated in quite a number of other bills. We have been supportive of the Colorado and Connecticut direction with the awareness that they can be refined, but of the view that if we don't have some convergence or interoperability, even if it's not perfect, we're going to end up with a terrible patchwork that makes life enormously difficult for both consumers and businesses. And so we think state legislators will legislate no matter what we say or do. I was a state legislator. I'd be working on AI now because it's the sexy thing to do. Legislators fill a void. You can't tell them to go home and do nothing. You can't say, here's what works, here's what doesn't work. And by the way, can you all do this in as much harmony or synchronicity as feasible? That's our only agenda here. Don't do things that are contradictory. Don't do things that break AI. We are sensitive to the fact that it needs to be work that small businesses can handle. EU AI bans things. The guidance came out around the subjects that are banned, and it's 100+ pages of guidance. Most of the state laws do not ban anything. Luckily, most of them do make a distinction between high risk and low risk, with either no obligations or minimal on low risk and more significant on high risk. But high risk could include a lot of stuff, right? Well, no, most of these state laws actually are focused on traditional protected legal rights, housing, employment, and so forth. So why do you even need it? Well, legal experts do argue that some of the state laws have gaps when it comes to digital. I'd argue, if you can't discriminate on housing, it doesn't matter whether it's done digitally or not, but some of the laws aren't clear. And then again, if you don't have the transparency, say, well, I don't know. I just use the algorithm to hire people. I don't know. And then in the end of the day, it turns out your algorithm is in effect discriminatory because somehow it creates proxies for race or for religion, decides that all the Jews are good, all the Jews are bad, right? Who knows? Who the hell knows what kind of, learning that's out there. And you don't know. You just know the algorithm is choosing these candidates, right? You'd be violating civil rights laws, but it may not be clear. The information may not be there. You may not be intentionally doing anything. In any event, these are the things that are driving the concerns of many of the legislators. But by the fact that they're tracking to those laws as opposed to sweeping super wide the way the EUA Act does, the way California, for instance, some of the critics have been worried that we'll have laws like Colorado or Connecticut or Virginia. Well, the Colorado Privacy Agency, again, in Europe, it's about GDPR. The Colorado Privacy Agency is in the midst of an incredibly detailed AI rulemaking. That's where the Silicon Valley folks who are concerned and who have some input ought to be focused. The lead advocate for the California privacy law, the real estate investor who led the ballot initiative, has been one of the critics, saying that there's no mandate to go in this direction, to go this far. That's where the agency is driving, and if you disagree, that's where you need to have input, because that's happening by regulation. Plus, California legislators are introducing large, expansive bills that go way beyond any of these other state bills that I've talked about. So Silicon Valley folks who have bigger voices, this administration or in this political environment, take a look at what's happening in California. And when you look at the other states, recognize that these are not in any way modeled on the EUA Act. They are modeled on traditional notions of security assessments, and that they all are far narrower in their scope, how much they demand AI play, the highly primary role versus just contributing to a decision, the scope. Many of them don't cover sort of the models, but rather the deployers. Anyway, lots of detail and huge distinctions. Final things to talk about, and then I'll wrap up. Google has provided information about how the new versions of incognito, which are default off, but are the higher privacy mode that you can turn on, initially kind of a don't look over my shoulder mode, don't allow others to see, but increasingly providing as well blocking against the sites that you visit. One of the concerns has always been that there's so few people using incognito mode that having it on is a privacy vector, an attack vector, and that using IP address and other data like that could result in you being more identifiable. Google has published a list of the companies, the kinds of companies that show up in sort of third-party tracking and targeting context, and those will be blocked in incognito. And Google-related ads and so forth will be blocked as well. So treating themselves the same as others. So some in ad tech have been concerned because it could block ads. Well, it's default off. Well, but they say, well, but it could be default on. Come on, we can't have it both ways. The privacy tools that are built, that are there, that are off, but that are there to be turned on, need to be effective. If they're not effective, then you don't have a serious argument that you've provided a real privacy tool. So we can't both argue, hey, these things should be default off. Oh, and by the way, when they're on, they shouldn't be effective either, which sort of undermines the whole purpose. So I'm all for the defaults being carefully debated and discussed so that they treat different companies fairly, support the ad business model in a limited but reasonable way. But when someone does go take the trouble to go find a setting and turn it on, it's got to work. If the opt-out cookies or the browser controls worked from day one, or at least even today worked, we'd be in a much better position to say, hey, what's your problem with ad targeting regulators? Look how easy people can just turn it off, right? Yes, it's on because we want to support, content and effective advertising. But if you don't want it, look how easy, click, you can turn it off, right? The criticism always was, here's why they don't work, here's how they're faulty, here's how they don't deliver. So I'm glad to see the tools delivering. And yes, I do hope that the default should be off. Sorry to the privacy advocates in the room, until you show me how you're going to fund the news media and so forth. And don't get me started by saying contextual ads. A, I don't know what those are. And B, I know that there's nothing that fits the context today of Elon Musk in government and Ukraine and Gaza and all of the front page disasters happening around the world. You'll have an internet where all the ads and the content that therefore will be there to provide the context will all be about asbestosis and who should be sued, and auto ads and stockbroker ads and the highest CPM, the highest value ads, and then that'll force and limit the ability for the media and others to provide the range of content that exists. So, not a fan. Do think we need ads. I do think we need responsible tools to measure, and we need to debate carefully what the right balance is. Doesn't mean your data gets to be traded and sold everywhere, and that the controls can't work and nobody has any autonomy. But there's a debate and trade-offs that matter. So anyway, well, that's a lot. That's a lot. Anyway, thanks for catching up. And of course, as always, welcome comments or questions.